Hey guys, welcome to the DarshanTalks recording and podcast. On this podcast, we discuss life science, legal, and regulatory issues, especially in the context of medical affairs, clinical research, and promotional compliance. If you like these videos and podcasts, please like, leave a comment, and subscribe. Darshan Talks. I'm your host, Darshan Kulkarni. I'm really excited because I get to have with me, for a second time, Paul Thaler. And before I go on, I want to talk a little bit about the topic, which is going to be about research fraud. Hopefully, we're going to talk a little bit about allegations of research fraud. How does culture play into this? I mean, there's a whole idea. The FDA has put out this whole idea of we want diversity in our subjects, but there's also a question of diversity in our investigators. And how does that diversity play to research fraud is a good question to ask. So before we get started, I'm going to have our guest introduce himself. So Paul, could you tell us a little bit about yourself?
Hi, Darshan. Thank you so much for having me back. It's a pleasure to be here. Sure. I'm a lawyer at Cohen Seglius. It's a Philadelphia-based firm. I manage the DC office. That's where I am right now, and it's where I'm from. I specialize in an area of the law, which is fairly small in terms of the number of lawyers who work it, representing primarily scientists accused of research misconduct. I've assisted institutions as well over more than 30 years of doing this work, but most of what I'm doing is representing the scientists who are accused and helping them through a very complex process.
So let me start by asking a question that I think is honestly quite simple, which is when I deal with scientists, one of the things I've found myself oddly dealing with, and this is a repeating situation, is it's really tough to get scientists to pay up because institutions are a little bit more open to understanding what this costs and how it can be an expensive process, understandably so. But scientists are often taken aback. How do you help address expectations so that it's a relationship that's built on trust?
You know, that's a really great question that you're asking, because it is a topic that comes up almost daily with me in my practice. You're absolutely correct. It is a hardship for scientists. It's a hardship for people to have to pay legal fees for anything. But if you need a lawyer, you know, there's not like the equivalent of medical insurance. You're going to have to figure it out. We have very frank discussions about what it could end up costing. I am loath to give them any kind of cap or even a range, because each case is so different. It depends a lot on not only their allegations, and I've had clients who have dozens of allegations versus client who just has one allegation. That makes a difference. Makes a difference which institution is handling the matter. There's some institutions that are quite adept and know how to do it, and it actually ends up saving my clients some time and money because we don't have to deal with things that shouldn't be dealt with. It also matters if they are exonerated at the very first instance at the inquiry committee level before it goes to full investigation. So clearly there would be fewer hours that I would need to spend, or anyone on my team, in helping them. But it's a practical problem. And you're right, scientists typically are not wealthy people. And yet, if you recall our first conversation, this is a serious threat to their career reputation. So you have choices. You don't have to have a lawyer, and most scientists try to do it without. And I've been called at every stage of the process because sometimes they do want to try to do it themselves, and then they have a problem and then call me later, which, you know, we deal with whatever we are handed. So it's a practical problem. I certainly have discussions not just with my clients, but with my partners, because you really have to, you know, we're running a business here, and I tell my clients it would be great if we could all do this for free, because I understand what's at stake. But I'm one of many partners in a law firm that this is our business, And if I sell my time to a particular client and I never get paid, and that time's just gone, and we can't, so I have burdens on every side that I have to address. But I'm very sensitive and empathetic with individual scientists who are trying to do their best in science and have a problem that needs to be dealt with.
So that really raises the question at something you sort of hinted at a few seconds ago, where you talked about this idea of research misconduct. And I find that to be a euphemism often for allegations of research fraud. And what that really speaks to in my case, I grew up a large portion of my life in India. And a lot of culturally, you tend to couch things in euphemisms. So my question for you is, when I get calls on, for example, one of the things I find myself dealing with is clients inevitably go, I just have a small problem I'm dealing with. I just wanted to pick your brain for a little bit. And then you start digging into it and you start going, that's not a small problem. It's not just a minor issue. You're dealing with a game-changing scenario. What has been your experience on clients calling, trying to potentially minimize the problem they're facing and or not understanding? Is that a cultural issue? Is that a lack of communications issue? Or what are you sort of dealing with? How do you sort of peel that onion?
There are a lot of issues that arise when a client calls. One, if they've called me, then they recognize already that there's something amiss and that need to deal with it. Research misconduct as a term is a term of art within the industry, if you will, that really applies to specific things: falsification of data, fabrication of data, plagiarism. That's the federally recognized definition of research misconduct. Now, as we spoke about last time, each institution that is charged with conducting the investigation as to their particular professor will have their own policies. And sometimes it's slightly broadened, but typically they're going to follow the federal policy. So research misconduct is just that. Now you mentioned if they call and they have some misunderstandings. One of the things that I have learned to appreciate over the years in representing hundreds of scientists all over the country and internationally, by the way, is that it does matter their background. Not so much because they'll get treated necessarily differently, although I'd like to address that too. But they have, just as all of us have experience as we grow up, as we go to school, as we start our professional lives, the impacts that we have from other people and from our families and from our national culture matters, and they all develop you as a person. So that person, after many years of being impacted by all the stakeholders, all the outside sources, come to me, and they do have different perspectives. But I don't know if you want to launch into a discussion about culture in this practice, because it's fascinating to me. And I think it's a necessary issue to address as institutions need to manage these processes and frequently forget that their scientists could be coming from a different perspective. I'll give you an example. Many, many years ago, one of my early cases dealt with a professor at a major university on the East Coast. I never talk about names or even the institutions because they all have confidentiality protection. We went through an entire process, all the way through investigation. And the primary issue with this particular scientist, being from China, was a very, very thick accent that was the reason why he was frequently misunderstood, and that played a role in ultimately a couple of the allegations being found to be, he was found responsible for research misconduct. We then got a letter from the dean saying you're hereby terminated. It turns out he was a tenured professor. Tenured professors are afforded additional protections. So I had to remind the dean, you can't just fire my guy. You have to go through your tenure revocation process. So we did that. And it's almost like a trial on campus with a Senate committee comprised of about, I think it was maybe 6 to 8 members of the community at that university to hear the evidence back and forth. So the dean testified, and he spoke on behalf of the university first, and then I cross-examined him. I said, I'm wondering, have you ever met my client? And he said, yes. And I said, when was the first time you met my client? And it turns out the first time the dean, who was trying to fire my client, had ever even met him was in the hallway outside of the hearing that day. And that's important because he didn't appreciate how much of an accent my client had and how that would have played a role. Now, that wasn't the reason why we ultimately won. We had a good case and we had good testimony and so forth. But that matters, and that could have impressed the dean before he decided that this person needs to be terminated. So he's still there, that professor. But there are other demonstrations of cultural impact. I'll give you another example. If someone says, I'm sorry to you, what does that mean typically?
So I've faced an issue like this. In some cases, it's a declaration of guilt. In some cases, it's a cultural issue of simply saying, I recognize what we're facing right now. Exactly. And so there's finesse to language. And there's some words we don't even have any. The German word Schadenfreude, the enjoyment of other people's suffering, there's no English word for that. So right. Same thing. So we say, I'm sorry. And depending on where you're from, they could mean that they just regret that this happened and, but they're not necessarily admitting guilt. Now, sometimes they are. A kid says, I'm sorry. They're trying to get out of something. But it matters. And so peeling away the onion, as you asked for me to do a few minutes ago, the person receiving the communication from the scientist needs to do just that to get a better understanding. How about the term N/A? What does that typically mean? Usually not applicable. Right. But what else? I've got a whole list. Not applicable, not available. So yes, absolutely. In the demonstration of data, so if they wrote NA, maybe it's not available. Not approved, needs assessment. Yeah. I mean, there are a lot. And so you can't just assume something as stated from a particular person. You have to understand where that person's coming from. And sometimes it's language and where they're originally from. And sometimes it's not just language, it's language and the industry and the part of the industry they were from. So I imagine someone who's Canadian, I'm making this up for some apparent reason because you start with I'm sorry, but someone who's Canadian worked in manufacturing may be looking at data points saying not available, while the same person, if they would have gone through academia, may say not applicable, and that may mean something completely different. So your point's well made, your point stands. So and also these people coming from different parts of the world are trained differently. Yes. And during the course of the training, they might be instructed a certain way of managing data that's different than they would be expected to do here at a university in the States. Yeah. So if someone from another part of the world is asked to beautify data, and I've had these cases, so what does that mean? Well, depending on where they're from, they could think that they have to make the data look like what their PI wants them to look like, or it could just be set it up so that it presents better and, in a fairly innocuous way, not intending the PI, not intending to falsify or fabricate data, but just to present better. But to someone who's not that familiar with terms or this type of process, they could interpret it wrong very innocently. So that's why part of our process is not just figuring out if there's research misconduct, but also what was the intent?
what did that person intend? So part of what I end up doing in those sorts of circumstances is explaining that, yes, they did say, I'm sorry, but they didn't mean that they were admitting guilt. They were saying that they regretted that this happened, that sort of thing.
It's kind of interesting to me, again, growing up in India, one of the most famous issues in India is the infamous Indian nod, which no one knows what to make of it. Yeah. It's some version, and you don't know, is that a yes, is that a no, is that a, and right. What you land up explaining to people is it's a I hear you. That's all it means.
Yeah.
It doesn't mean I agree. It just simply means I've heard you.
Yes.
But no one seems to understand that because it's neither a yes nor a no. And that's exactly the point. And that could be very easily misunderstandable, if you will. But let me ask you a question that comes out of this. I mean, we talked a little bit about accents playing a role. One of the other issues I can see playing a role is the idea of, you talk about, I'm sorry, but the converse of that is machismo. And people trying to sort of save face by being aggressive, because culturally, taking a step back would be an admission of guilt. How have you dealt with that situation? How does that get interpreted, and how do you sort of play around with that?
Sure. Part of the difficulty in assisting clients who have never had this sort of problem is that they are approaching it with an attitude that they have cultivated by seeing movies and seeing TV and deciding, I'm in this pickle and this is how I'm supposed to behave. So you're exactly right. There are some who are just scared to death. There are also some who are way overly aggressive. And in my work, I have to remind them constantly, this is not litigation. So we are advocates for our clients, but we are very respectful to the general counsel, to the RIO, the research integrity officer, certainly to the committees, to the investigation committee. You always have to be very respectful. You can't just come out like a litigator with guns blazing. Why? Because that committee is making decisions about you. You would never come out and treat a jury or a judge poorly. So I have to get them to reverse that kind of approach. I don't want them to be too timid. I don't want them to be too aggressive. Even keel, when they appear for their interviews, we talk about how to handle the interviews, but it's always respectful. And that little bit of machismo can really turn off the committee and get them against you, and think, that you don't want them to have any preconceived notions of who you are or how they want to treat you based on your attitude.
Which really brings this other question you talked about a few seconds ago, where you talked a little bit about this is not litigation.
Yes.
Litigation usually has a discovery component.
Yep.
Have you, in the matters you're dealing with, have you dealt with discovery in these contexts? How does that sort of play itself out? And how is it different from a typical litigation matter?
Okay, so I have also been a litigator for more than 30 years, about 35 years now, I have to say, in an embarrassing statement. And in the course of litigation, as you correctly point out, there's this discovery process, which is kind of in the middle of the whole process. Not so in research misconduct. In research misconduct cases, the respondent, that's the scientist, really doesn't get to see much of anything until it's largely played out. And that's at the end, after the investigation committee has done its job, prepares a report. Then by regulation or rule within the university, the respondent is entitled to the entirety of the record upon which the committee relied. So at that point, it's full disclosure, no holds back. I mean, they just have to give them everything. And that actually, we do have occasionally some scuffles with the general counsel or the RIO, making sure that we get the entirety of the record, to include transcripts of the interviews with the other witnesses. Keeping in mind, as I said, this is not litigation. The respondent never gets to address his or her accuser, the complainant, never gets to cross-examine witnesses, never gets to present anything, as I say, until the draft report. Now, we frequently will try to get in front of the committee a submission to help create or formulate their conclusions before they get to a draft report. But according to the rules, it's not at all like discovery where the other side has to give you a whole bunch of stuff. In fact, the very first step is kind of like that, is sequestration. The university takes the laptop, the notebooks, and so forth from the scientists even before they've told the scientists what's going on.
Right. Which again has this impact of causing the scientists to be on the back step and causing the scientists to not even know fully what they're responding to. And when I find myself advising clients, I find myself in a position where the scientist wants to address every possible theory that they might have in their heads on what they're facing. And that's not the most productive way to spend either the energy or their money or time. So how do you help corral your clients in a way that they're not going after every possible tangential lead that they have in their head?
Dealing with clients and their heads is an ongoing problem too. You correctly point that out. As is the case with many of us, we are constantly talking to ourselves in our mind. And during the course of a day, you're having an argument with someone in your mind, and you're even providing their responses. And then that's making you mad, and it goes on and on.
You're usually winning, though. You're often winning those arguments in your head.
Always want to win. But for scientists, it's so peculiar, this process, and it's so bewildering that they will try to spin out, what are all the different things that I might have done wrong? They frequently will know once we see the allegations, and that usually happens pretty early on. So at least they'll see what they're accused of. Then they will be able to address those. But there is a lot of me reminding them that this is a process that will go on for a while. They'll have opportunities to say what they want to say. But I also ask them to resist the temptation. I call it the telltale heart syndrome. If you remember that short story by Edgar Allan Poe, the murderer who has successfully murdered someone and has buried the person underneath the floorboards of the living room, the police are walking around and without prompting just screams out, there, below the floor. That's where the heart beats. So resist the temptation just to blurt stuff out that they might not be asking because of the dialogue that's going on in their mind. So we have to tame that.
So that raises the next question, which is the issue of burden of proof, which is you've now got a situation where these individuals, these researchers are dealing with game-changing, life-changing allegations. And the university has to meet a certain burden. Could you talk a little bit about the burden of proof required that the university has to meet?
It's actually a pet peeve of mine. Okay, so, and here's why, Darshan. The burden of proof in these matters is preponderance of the evidence. Okay, seems simple enough. So preponderance of the evidence, as we all learn in law school, is just slightly more, the weight of a feather more than 50%. And that's what the investigation committees are charged with in making this decision. Was this or was this not falsification of data, fabrication of data, or plagiarism, and what was the level of intent? Preponderance of the evidence. Well, what is at stake here? What's at stake here, as you correctly point out, is the career, the reputation of a scientist, and anyone who's progressed to the stage that most of my clients have progressed have spent decades cultivating that, getting educated, going into a lab, being a mentee, learning things, maybe being a PI now. And now they're faced with a huge threat to that career and reputation. So is preponderance of the evidence the appropriate standard? And I've wrestled with this for many, many years. The preponderance of the evidence shows itself elsewhere in civil trials. And what's at stake there? What's at stake there is money. So we compare that then to the other standards available in our systems. The other one that people know is beyond a reasonable doubt in criminal trials. What's at stake there? Liberty. So you have, and so to most people, and I say most, and I'll explain why in a second, to most people, your liberty is the most important thing. So it has to be a tough standard to take away your liberty. Because if I can't be in society anymore, I want someone to really be able to prove beyond a reasonable, it's not shadow of a doubt, it's beyond a reasonable doubt in a full trial. So that's your liberty. So is taking away your career, your reputation, closer to taking away your liberty or closer to taking away your money? Most would say it's somewhere in between. Now, I made a joke a minute ago about most people view liberty as the most important. There was a great routine by a comedian who was on the radio, Jack Benny, many, many decades ago, where he was, so his shtick was that he was really cheap. He didn't like to spend money, he didn't like to give money. And so one of the routines was he's being held up and the robber says, your money or your life. And then there's a pause on the radio and you don't hear Jack Benny say anything. And the thief says, I said your money or your life. And Jack Benny says, I'm thanking. So that's the exception.
Right.
I love that joke. But most people, liberty is the most important thing. There's another standard, and that's called clear and convincing. That's kind of in between. So you have preponderance of the evidence for money damages in civil litigation. You have beyond a reasonable doubt in criminal cases, which is taking away your liberty. But there's another standard, clear and convincing evidence, that is found, it's tougher, it's much tougher than preponderance of the evidence, and it's found in certain types of cases that are much more serious than just, say, a breach of contract. To me, that might be the answer, that the committee has to find by clear and convincing evidence that this scientist committed research misconduct because it's such a serious threat to someone's career and reputation. And that's a big deal. I think it's more of a big deal than just having to pay someone some money damages because you breached your contract or maybe hit them with your car. And most would say it's slightly less serious than something that would take away your liberty. But it's serious. And so to me, the existing burden of proof is way too light.
It's an interesting idea. And I'm wondering, I've negotiated these agreements all the time, clinical trial agreements all the time, and I've negotiated physician employment agreements as well. I've never seen anyone inject a clause in there saying any claims against me need to meet the standard of clear and convincing evidence. I don't know if I got that sent to me, I'm not sure I'd necessarily even object because it's such a under the radar type of issue. But what would your experience be if you got a contract like that? Would you sort of call it out? Or
okay, so a contract is it's a deal between two parties, usually
right.
two parties, and it's a civil
sure.
agreement.
Sure.
So that would be different if I were you and someone sent me a contract that included a higher level of burden of proof. If there was a dispute arising from the contract, I would resist it because I don't know why my guy in this contract needs to be held to a tougher standard than the rest of the world. So I would say I'm fine with preponderance of the evidence if there's a breach, you know, because maybe I have to sue, maybe my guy has to sue the other guy. Clear and convincing is usually reserved for like fraud or
right.
if someone's trying to pull the plug on someone who's got brain problems or so.
Right.
So it's a tougher standard for a reason because the subject matter is much more serious.
Right.
But in a contract setting, I would be surprised to see someone try to beef up the burden of proof.
I've never seen that done either, which is why I'm asking the question. I'm kind of now going, when I think about most of my investigators, right, I'm usually thinking of the average investigator is not trying to sue the sponsor. I recognize that your practice is primarily against the university, but if I do a lot of non-university work as well. So it might be a small site negotiating against a sponsor. And the large sponsor typically has, farms of lawyers and non-lawyers negotiating these contracts. And inevitably, my client is usually going, I want to make sure I get paid, and I want to make sure that if something goes wrong, I'm not kind of bamboozled. It's unlikely for the most part that you're going to go sue the sponsor because it's just not worth it in most cases. But so it means that you're really defending yourself most times against you being sued. And if you raise the burden of proof contractually, it might mean that you give yourself a little bit more wiggle room, because if someone says, oh, you have breached this portion, show me by clear and convincing evidence that I have, then we'll have this conversation.
The courts will not step in. If the parties want to create a burden like that, a burden of proof, I don't think the courts would say you can't do that. I don't think it violates public policy. Usually when I'm in the position of what you're describing, we would include legal fees have to be paid by the breaching party,
right,
or some other deterrent to help ensure that the contract is not breached. But I suppose that there have been and could be private parties that decide that we really want to make sure that if someone breaches, that the non-breaching party can prove it to the satisfaction of a tougher standard. And it could, and also you frequently see arbitration clauses, just handing it over to an arbitrator. You can pre-select that person, and you can decide we want someone who's really tough and it's going to really beat up the people. But private parties can do whatever they want in a contract for the most part.
Yeah, no, this is interesting. Thank you. We can keep going, as you can tell. There's so much here to explore, but we're a good time past our usual allocated time. So before we go, Paul, any last parting words?
I really appreciate the time with you, Darshan. I found it extremely interesting both times, and I thank you. The world of research misconduct is a scary place for scientists to find themselves in. I'm happy to have been able to help many scientists get back on track. If I've done a good job, you will not know that my scientist was ever even under threat. That's a good result. So that's what we try to do. We wish all the scientists well. We want the collaborative efforts of science to help us all. And that's, I play just a very tiny part in that, but I'm happy to do so.
Thank you. These conversations are not intended to be legal, regulatory, or clinical advice and may not be right for you. These conversations are intended for educational purposes only. Conversations on this forum do not create an attorney-client relationship.